Lawyers for Injured Workers, which also happen to be the sponsors of our podcast. If you have hit the subscribe button, thank you. If you follow us throughout the year, thank you. But if you have not, please make sure to subscribe so that way you get notifications every time we upload new content and support the information we're providing for all injured workers here in California. Today's topic is very interesting. It comes up a lot, believe it or not, and it has to do with settlements, and not the type of settlements that you're thinking of, but what happens when there's a settlement on the table and someone decides, I don't want it. That is what we're going to be talking about today. So, Bilal, it's all you.
So what happens when you don't take a settlement?
It happens a lot, right?
Yeah, it comes up. I think it's one of those things where it doesn't come up that often, but when it does, it's a really big deal.
Okay.
And so, I think more often than not, workers' comp cases settle or get resolved somehow. But there's always that one case where someone says, you know what, I don't want to accept what the insurance company is offering me. I want to go to trial, or I want to take my chances, whatever those are.
Right.
And it's those cases that I think don't get talked about a lot or enough, because usually there's some pretty significant issues in those cases, and people are risking kind of all or nothing. I think one of the contexts that comes up most is what's called AOE COE, which means if your injury is arising out of or in the course of your employment. So do you have a work injury that makes you entitled to workers' compensation? And sometimes there's medical, legal, or factual reasons why an injury is disputed. And so sometimes you have cases where people are offered a settlement, and that settlement doesn't necessarily represent the liability. Maybe they have a need for a total knee replacement or something really significant, but the settlement's $30,000, which is clearly not enough for a total knee replacement. But if you go to trial, you risk losing everything and getting nothing, which is a potential outcome. And that comes up pretty frequently.
Why? Why would someone want to go to trial and have that jeopardy of, I might lose everything? If you have a good attorney on board to your team and the attorney's telling you, I'm assuming attorneys do say, hey, this is not a good route you don't want to take. You should take $30,000 or you're not going to get anything, because there's something behind. There's something there that is preventing them from getting more.
So let's talk about that. There's a few different reasons why your case could be denied, right? Either a doctor says it wasn't work-related, or legally your case is barred, statute of limitations, for example, you waited too long to file, or the one I think that comes up the most frequently in this specific example, which is a factual dispute, meaning you say you reported your injury to your supervisor says that you said you got hurt at home, and so the case is denied. And even if your injury is really there, you really need a knee replacement, but legally there's a dispute about whether you should be entitled to workers' comp based on your side versus the employer side.
It's a he or she said. It's
right.
You against your company.
That's what trial's really all about. And so, in law, we always joke there's three truths. There's your truth, there's the other side's truth, and then there's whatever convoluted version of that comes out that the judge believes is the actual version of events, right? And so those are the three truths in trial. And that's the joke for a reason, right? Because it's true. I think there's what you say happened, there's what the insurance company and the employer says happened, and then there's what the judge ultimately finds as the facts. And usually it's some version somehow of both of those, because, I think people tend to kind of, I don't know, people have terrible memories, right? And so whenever people recount events, right, there's always some factual inaccuracies there, right? And I think that tends to be, I guess, magnified in trial a little bit. But the point being is, you can present your best case, but that may not be what the judge sees, right? The judge may see things differently than
Correct.
You do. Or the judge may find that the other person's testimony for the other side was more credible than yours. Or maybe it's you against 5 different people on the employer side. Or maybe it's the employer versus 5 people on your side who are testifying on your behalf. And so I think some people have the attitude that they would rather get nothing than something, because they don't want to cop out. They don't want to give up. They don't want to let the insurance company and the employer bully them. and that's cool. Morally, I agree with that. I think that's great. And I would love it if every client said, I just want to take every case to trial because that's what lawyers are there for. But there's the reality of taking care of yourself, your family, your loved ones, rent, whatever the case may be, that quite frankly sometimes trumps that. You're talking about a multi-billion-dollar insurance company. Them taking your case to trial isn't nearly as big of a deal as you think it is for them, but it's everything for you.
Right.
And I think sometimes people get caught up in that, and they want to be on the moral high ground. They want to be right rather than they'd rather take some money and walk away.
Does that usually come up in a negative situation? Meaning, let's just say there is an employer who says that the employee hurt himself at home, and they have proof that this happened. And you as an attorney know that if you take it to trial, it's not enough evidence that's going to help your client out. You sit there and you tell them, this is not a good idea. If I were you, I'd take the $30,000 they're offering you and go from there. Mm-hmm. They sit there and they're like, they want to be right. No, I'm right. It happened at work. What happens when they lose?
So, a couple of things on that note. As a lawyer, I have ethical obligations to represent my client's interests. That being said, it's not indentured servitude, meaning I'm not obligated to do things that I morally or ethically object to or legally object to, things that I don't think I can support. Because part of my ethical obligation is vigorously representing my client's interests. And if I don't think my client has a case, mm-hmm. ethically, I don't think I could take a case to trial, because I can't sit there and say, I'm going to do the best job possible for you and crush it for you. If I'm sitting there thinking to myself, oh, this is the worst case possible to take to trial, I'm going to lose 100%. There's no chance in hell I'm going to win this. And so I think usually I have an ethical obligation to tell the client, like, hey, look, I just don't believe in this. I don't think you have a strong case. I think you're going to lose if you go to trial. Quite frankly, I don't want to try the case because I think you should take this settlement. And, it's up to the client to say, okay, well, maybe I'm going to find a different attorney who wants to take a second look at this. And that's fine. We have reasonable people who differ in opinions, and maybe there's a different attorney. But if we get to a case and we take it to trial, and, maybe it's a 50-50 shot where I'm not confident or I don't feel good about it, but I still think there's a chance, and we take the case to trial and we lose, there is an appeals process.
Right.
The appeals process is rather limited. The judges in trial court have a great deal of deference, meaning when it comes to the appeal process, the appeal level, they're really looking to see whether or not the judge did something wrong. Not so much whether the judge made a mistake in judging credibility.
Right.
So if you go to trial and lose, and it's because the judge found that the other witnesses testifying against you were far more credible than you were, the appeals people they're not going to overturn the judge's decision.
Right.
They're going to overturn the judge's decision because the judge incorrectly didn't admit evidence, or the judge ruled against a motion for something else or somewhere, or the judge said or did something that was incredibly biased or discriminatory, things like that, abusing their power.
Right.
But once you get to that appeals process and you lose, that's called a reconsideration. There's one level above that, which is the court of appeal, which is the same court that you'd go through in civil court if you wanted to appeal. And again, they're looking at it from the same perspective. Did the judge err legally? Not so much did the judge, were they a bad judge of character or something like that. You could technically go all the way to the California Supreme Court, I guess, but those again, that's based on, did the judge err in applying the law or procedurally do something inaccurate or something like that. The California Supreme Court's not going to take the case or hear the case. They don't even have jurisdiction to hear a case because the judge thought you were not credible.
Right. There's no such thing as that. Yeah. So ultimately, you don't get the settlement and you lose the trial.
And that's that. I think it depends too on what you're talking about when you're talking about going to trial. You can go to trial on the fact that the injury is either covered by workers' compensation or not. You can go to trial on various small issues, like whether or not you have a certain level of permanent disability, whether a QME report, for example, is considered substantial medical evidence that the judge relied on. So there's there's a bunch of various things that you can actually go to trial on that aren't necessarily all or nothing for the case.
Yeah.
I think when you're talking about the situations where it's all or nothing for the case, and in the context of that, talking about settlements, I think there's also the component that people want to go to trial because they want something that they can't have. So like in workers' compensation, the damages you can get are limited. And so they may be offered a settlement that, from my perspective, is reasonable.
Right.
But it's just not something that, they find appealing, and they want much more than that. And that's not something that they can get in workers' comp. So you run into a situation where sometimes people end up going to trial and, getting less than they would have or nothing because their expectations weren't in line with what workers' comp can offer.
What it actually is, what the truth behind workers' comp is. Because you're right, there is a couple of people who believe they're going to get rich because they settled in workers' comp. An unfortunate incident happened to them, and all of a sudden they're going to have their hands on so much money and it's going to help them in life. But that's not how workers' comp works. For the most part, you'll be lucky if you got the medical treatment that you needed and that you got taken care of, and some. But you're right. There are people who are offered $30,000. Well, I feel I should get $100,000, and I'm going to go for those $100,000. Do you see that?
Yeah, and you know what? I feel for those people because dude, you should have $100,000. I agree with you. You should have $1 million, right? As the attorney, look, we operate on contingency fees, which means as an applicant attorney representing injured workers, the more my clients get, the more I get.
Exactly.
I run a for-profit business. I have every incentive in the world to get the client as much money as possible because that means I can feed the people and provide for the people that work for my firm. Those people can provide for their families and such. We can stay open. We can help more people. That's just the nature of the business. So it is a disservice to my own self-interest or the attorneys that work for us or anyone at the firm to get less than what we can for the client because no one's winning. And so we always try and get the clients the most money possible, but there are clients who come in who have an abstract number in their mind and they want that number because they feel as though that's adequate, but it's not necessarily tied to anything in particular, and they don't really understand the difference between, what they may see in commercials or when they hear about their friend's case who got X number of dollars versus what they're being offered, and not understanding how all those things align and what's possible. And I think that causes problems because then they have this expectation that they're going to get far more that even in the best case scenario they could actually get in workers' comp.
Right. And we've talked about this scenario particularly in other episodes where we've mentioned when the insurance company knows something's up and they want to cop out, they offer you more than what they should because in the long run, they're going to spend more if they continue it. So they kind of just want to shoo you away with giving you double what you were supposed to get. And that's where those stories go out and people are like, well, he got this much for only this injury. Why am I not getting my part type of stuff, right? So it's a lot of those misconceptions and setting yourself up with expectations that are not realistic in the world of workers' comp.
Look, every adjuster, defense attorney, judge is different on every single case.
Yep.
I could get the easiest pushover insurance adjuster with the easiest pushover defense attorney on a really low value case, and they'll offer crazy money to get it solved because they don't care. They don't know what they're doing or whatever. It doesn't matter to them. Then you could have the same case, same injury, same everything with a career adjuster who's got like 20 plus years experience, who is sharp, and their sole purpose is to save as much money as possible for the insurance company, and a cutthroat defense attorney who treats the insurance money like it's their own mother's,
Wow.
And they treat it incredibly personally, and everything is a fight for every penny.
Right.
And yeah, of course, those are going to end up being two different results because you have such a different set of facts and circumstances. Right. And it's just that same person on one case could get $50,000, on the other they could get $200,000. It just really depends.
Depends on what foot they woke up on that morning. I mean, it could be a female literally going through something, she's in a bad mood, and she's just gonna be like, you know what, today I'm not gonna cooperate with whatever I'm doing. Mm-hmm. Yeah, it's essentially different for every single case. So ultimately, when you don't accept a settlement and you decide to go to trial, can you give me numbers in the sense of how often does this turn out bad?
Uh,
90% of the time?
it depends on, I think it's hard to describe without going into too much detail, but I think the issue is what are you going to trial for?
Okay.
Because workers' comp judges have limited authority and jurisdiction. I think the important part to realize about workers' comp is when you go to a trial, you don't get a jury. It's not like...
You have to convince a ton of people to hear your story.
Yeah, you're not going to go in front of a 12 of your peers who are going to hear opening statements and be able to award things like punitive damages and things like that, who are going to sympathize with you and connect with you as people. Not to say the judges don't, but it's a bench trial. It's administrative law, so you have a judge deciding the case. And the judge only has the limited authority to award certain things. The judge can't award you, lost income based on some economic expert that you present. They can't award you punitive damages because this thing that the plaintiff or the defendant did was so bad it deserves to be punished. They can't do that stuff. So when you're talking about what a judge can award, they can award you temporary disability. They can award you permanent disability. They can award you future medical care. They can award you job displacement benefits.
Right.
They can award penalties and sanctions if there's wrongdoing in a case.
Mm-hmm.
That's kind of it. So
wow. I'm glad you broke that down because I don't think that's what a lot of people think.
No. And so, there are some circumstances where they can award more than that. In the case of, for example, discrimination based on filing a workers' comp case, they can do back wages and stuff like that. But that's very limited. When we're talking about just generally a workers' comp case, which is 95% of settlements, I think you have people who want something, they're not getting that, so they want to go to trial. And then the question was, what happens after that? And so if someone, for example, is not happy with the amount being allocated towards their future medical. So like, let's say they have a back injury, they're getting 25 grand for permanent disability, 25 grand being for future medical care. So 50 grand totals the settlement offer. And they're like, I want more than that. And if they can't give me more than that, I'll let the judge decide. Well, the judge has no power to award money in lieu of future medical care. So that means that if you go to trial, the judge isn't going to say, defense attorney, insurance company, give this man $80,000 for future medical plus $25,000 in permanent disability. So, in the future medical sense of things, sometimes we get to a point where there's two different numbers. There's what your medical is actually worth to you as a person out in the free market paying for insurance or out of pocket. And then there's what the insurance company perceives its financial liability to be. And we can't force the insurance company to pay more than what they want to pay for to buy out your medical.
Right.
So in that case, going to trial isn't going to necessarily accomplish anything. It's just a question of how far can you push them to call their bluff, because maybe they really want to close your case. And so maybe they don't want to actually have open medical care. Mm-hmm. And in that circumstance, sure, pushing it towards trial might incentivize them to pay more to close it out than they're comfortable with. But I'd say that's a rare circumstance. It's not as often as people think it is, especially if you're not using your medical all that much,
Right.
If you've cost them $5,000 in medical and then you want $80,000 to close out your medical, they're going to be like, no, this is like... There's no way we're going to spend this much.
Right.
So,
I'd rather still deal with you for the next 8 years and keep paying $5,000. That's it.
Yep.
That'll be cheaper to deal with you until you get tired and give up.
Yeah. The judge will just, in that case, if you went to trial, the judge would award you future medical and you would have your future medical. Mm-hmm. You can't force them to buy it out.
Yeah, but then they start blocking you with the denials of everything. You have future medical. Yeah, you're going to get future medical. But guess what? That approval to get the prescriptions, it's going to take you like 90 days. That appointment you need to go to for therapy is going to take you 90 days. And they're going to wear you out. So,
yeah, but, that's one thing. Permanent disability is something you can go to trial on.
Yeah.
And that may be something we're going to trial as actually a net benefit to you. Like if the defense has a doctor's report that says your permanent disability is 2% from your treating physician and you went and got a QME report that says it's 50%. So it's a pretty big difference in value to you. Yeah, you'd go to trial to fight over which medical report is accurate. Yeah. And so that's something we're going to trial. Afterwards, you get a net benefit from.
Right.
So again, I think it just depends on the reason you're going to trial and what it is you're hoping to accomplish, and understanding whether or not what you're hoping to accomplish is something that's even feasible, right? That the judge can actually do for you.
So what you're saying is, if I think I am worth $100,000 and I got offered $30,000, there's no way in the world that I can just go to trial and hope that the judge is going to give me those 100, because it's not even in his authority to be able to give that type of money. Like,
depending on what it is, yeah, the judge may not even have authority for it. You know, the judge has the confines of the law that they work in, and there's certain things that I think people want and should get, they just can't, you know, it's just the way the law is set up. But I think it's really important to understand what you're entitled to before making the decision whether or not you want to go to trial. And in fact, if you have an attorney and they're telling you,
don't go to trial,
hey, look, don't go to trial, or they're literally telling you, you can't get that, like the judge can't decide that, the attorney's not just making that up. You know, they know. And I've had clients where they tell me, they're like, Bilal, I want to try the case, I want to go to trial, it's up to the judge, whatever the judge says. And I'll tell them point blank, like, the judge can't do that for you. Like, they absolutely can't do that for you.
What do they say? You're lying. I'm going to another attorney.
You know, sometimes yes, sometimes no. Sometimes they say, well, I don't care, and you know, they can be stubborn about it, and I get it. You know, it's their health, it's well-being. I want them to get as much as they can too, but you know, we're just being honest and open about it, because in the back of my head, I'm screaming, because I'm like, this person's like
about to make a mistake.
They're ruining their entire case, and they're going to drive this thing off a cliff just because they don't want to confront what I'm telling them. And it's a tough spot to be in. I don't want to deliver bad news to a client, but at the same time, my job's to save them. So if I feel like they're going in a direction that's not good for them, I'm telling them, and I'm like screaming from the rooftops, like, stop, don't do this. Like, you got a great offer. The alternative is something you can't have or want. It's going to be substantially worse or nothing at all. And sometimes they do listen, sometimes they don't. I think for the most part, if I break it down well, clients do listen.
Right.
But some people don't want to accept that, unfortunately.
And when they haven't accepted it and they go off that cliff after you've told them not to, do they come back and say, damn, you were right?
No.
They're just like, you suck.
No, you know what, though? Every attorney who's tried a case has lost at some point. Yeah. You know, I don't know of any attorney who's got a perfect undefeated record, right?
The new ones, what are you talking about?
There's no Floyd Mayweathers of trying cases. It's just, it doesn't happen like that, right? You win some, you lose some. I think a lot of times there are clients who say, you know what, I guess I should have taken the offer, things like that. There's other clients who are like, you know what, screw it. We tried, we did our best, we still lost, it's okay. You know, I got to be a thorn in their side and be a huge pain in the ass. I made them work for it. And you know what? If that's what the judge decided, that's what the judge decided. And I've made peace with that. You know, I've had clients like that too.
Oh, wow.
So, you know, and I've had clients where we've gone to trial and it's been like, that was a good idea. That was a really good idea. I'm glad we went to trial. And it was all or nothing, you know, and they came out on top.
Nice.
Yeah.
Yeah, that's definitely a really hard spot to be on if you're going to go into trial and your attorney's telling you not to. I guess, like you said, it's like everything. And it sucks to say this, but every case is different. It's the circumstances that lead you to go to trial. Who's your claims adjuster? Has the insurance company done anything to screw you over? Like, are they really screwing you over? Like, there's just so many things that go into it. And if you are truly trusting your attorney, then trust the gut feeling that they say you're not going to win.
I think there's another big circumstance where settlement comes up a lot and people don't take it, and it can wreck a case. Is sometimes people will be offered settlements before going to their QME evaluation. And it comes up where the insurance company wants to settle, they want to settle early, and they offer something that, I mean, maybe it's not great, but it's not bad. And they say, this offer is good for now. If we end up going to the QME, this offer is no longer available. And so the QME is the medical evaluator who really decides a lot of the...
Who puts the numbers.
Yep. And so if you haven't seen that video, check out our QME videos.
You can check it
out. It's a great
out
video.
On the description.
But sometimes that can throw a wrench in the works too, because, you know, you can have a QME who's maybe not as favorable as you think they are. And maybe your case was worth more, and then you saw this QME and they wrote this terrible report, and now the offer is completely gone or substantially less now.
Yeah.
And so sometimes there's components of the case that aren't really necessarily explored as much as they should be. But you have to make a decision. Do I want to risk going to this evaluation with this doctor who's potentially going to write a very negative report? Or do I want to take the settlement now?
Take the chance.
And, you know, just close it out. Peace of mind.
Right.
Sometimes when we say we're buying or we're closing cases with settlements, we're buying peace.
Yeah.
Each side gets to call it a day.
That's crazy.
Yeah. So.
I guess it's just destiny and the universe where it's going to lead you to. And if something was brought up to you, if it's meant to be, it's meant to be.
Yeah. Other than that, though, there are a lot of settlements in cases that come up a lot. We did another video on never accept the first offer, and that's usually true, right? There's a lot of settlements that come up, and there's no negative repercussion for not accepting it. Adjusters generally will kick out these letters for like $5,000 or $10,000 like immediately after the case is filed. And we have an ethical obligation to tell our clients about it, even though it's like an insulting offer. We still have to say, hey, they're offering you settlement. Do you want to say yes or no?
Yeah.
So don't shoot the messenger if your attorney is telling you that. We're legally obligated to.
Right.
But, they'll throw that money out there early just to kind of dangle a carrot to see if the client's interested. But you saying no or ignoring those, there's no repercussion to it.
Yeah. I'm glad you said it that way, though, because, again, this is in circumstances where they're going to try to offer you something knowingly knowing that they're just BSing you, because for the most part, when they do stuff like that, it's because there's something bigger on the other end. And of course, as an attorney, you would let them know. So
yeah, and we tell the client, like, hey, dude,
right.
That's not good.
Yeah.
Hold out for more. Like, clearly, like, the client sawed their leg off or something, and the adjuster sends a letter that says, hey, we'll offer your guy $20,000. It's like, okay,
yeah,
I'll tell the client, but no. But yeah, usually if there's the times where it matters most is when there's like a time limitation where the adjuster is saying this offer is only good for X number of days, or the adjuster or defense attorney is saying that this offer is contingent upon this thing not happening. Like, if we have to go forward with trial, this offer's gone. If we have to go forward with the QME, this offer is gone. Things like that kind of perk my ears up a little bit to say, hey, is there something that I should be concerned about here? And are they actually offering something that's actually pretty good depending on what could happen after whatever event that is, the QME or the trial and such. So those are generally the times I think it's important to be cognizant of what they're saying and whether or not you should accept it. And then if you don't accept it, what are the repercussions?
Interesting. I mean, there's a lot to dive into, but I think this was a very important topic to touch. Generally, because again, a lot of people believe that going to trial, the judge is going to award you and give you numbers from wherever they pull them from, but it's not the case. And I'm glad we touched a couple of subjects on this particularly episode that is going to help people understand what do you really expect at trial and what happens when you don't accept a certain offer because of X, Y, and Z. You're either left with nothing or nothing, literally.
Yeah. And it's every case is different. You can go to trial for a bunch of different reasons, but there are circumstances where you could end up with nothing.
Yeah. No, but I think this episode in general is speaking for those that want to go to trial because they feel that they're owed more, or they should be getting more because Bob told them he cut his finger and he got $50,000.
Every person in workers' comp is owed more than they get. I don't care how much they're getting in settlements. I don't care if you get a settlement for $5 million. Your case is probably actually worth $10 million. Workers' comp doesn't pay enough for medical. Permanent disability, for example, hasn't changed since 2013. We're in 2023. Post-COVID, it's been like 50% inflation over 3 years.
Literally.
Right? And so just the system doesn't compensate people like it should. And so even if you get everything you should get, you're still not getting enough. And so I think more often than not, people are left with this like insatiable feeling that they got screwed, that they didn't get what they should have got. And that's most cases, just because of the system.
Yeah. That wraps up this episode. We hope to catch you on the next one. Make sure you hit that subscribe and that like button. That way you get notified when we dump some new content. Follow us on social media. Make sure you drop your questions on the comments. We haven't done an FAQ video in a while, so we might be doing one pretty soon. Make sure you drop those questions so we can touch them on our FAQ videos. And if you've not yet jumped on and watched the FAQ videos where we answer other questions, you might want to check those out as well. There's a lot of information that gets answered on those videos. But yeah, we'll catch you guys on the next episode. Thank you.